My dad, Jay Secular, our chief counsel, is joining us. And Dad, we explained just briefly in the first segment of the broadcast the Fisher decision out of the U.S. Supreme Court, which a big decision on the two charges that have been brought against President Trump by Jack Smith related to January 6th.
So this is a decisive defeat for the special counsel, Jack Smith, and an overwhelming victory for obviously the petitioner in the case, who was a police officer, and the president, who's been charged. Two of the four counts relate to this obstruction of an ongoing act of Congress. Well, a majority of the court, 6-3, so it was a lopsided decision in favor of both the First Amendment here and statutory interpretation. But let me tell you the unusual thing here. Justice Barrett sided with the liberal members of the court, but Justice Brown sided with, in fact, the conservative members of the court, and that's how you end up with 6-3. Chief Justice Roberts said the Solicitor General acknowledged an oral argument that under the government's interpretation, a peaceful protester could be conceivably charged for violating 1512C2, which carries a 20-year sentence. And even lobbyists could be brought into the scope of the statute that Jack Smith was trying to interpret. By the way, typical Jack Smith overcharging, overreaction. But listen to the concurring opinion of Justice Jackson, again, appointed by who? President Biden. So they're not going to be able to argue this is the six conservatives. She said, in the United States of America, men are not subjected to criminal punishment because their conduct offends our patriotic emotions or thwarts a general purpose sought to be effected by a specific command which they have not disobeyed, nor are they to be held guilty of offenses which the statutes have admitted to define and condemn. Our commitment to equal justice and the rule of law requires the courts to faithfully apply criminal laws as written, even in periods of national crisis, and even when the conduct alleged is abhorrent. And she went on to say, notwithstanding all of this, this court's task is to determine what conduct is proscribed by the law, and clearly this was not. Now, this also has a huge ramification, Jordan, for the president's case, because two of the four charges relate to exactly this point. It's exactly the same statute.
Yeah, I mean, they were relying on his speech, and this is exactly what they were talking about today. Is the kind of idea of speech that, and you said, like in Judge Jackson's opinion as well, she was talking about how even a peaceful protester, so someone just giving a speech at a rally, would be subject to this, and that's what Jack Smith thought. But now, because of the way they defined it, and this is how they defined it, to prove a violation of this law, the government has to show the defendant impaired the availability or integrity for use in official proceeding. It's about records, documents, objects, and other things used in a official proceeding. So, Dad, a lot of legal commentators think these two charges fall now for Jack Smith, and if he wanted to bring anything similar, he'd have to go back to the grand jury with a different charge, a more serious charge, actually.
No way that's going to happen either, because first of all, the Washington grand jury has expired once the indictment was issued. They'd have to retool up a grand jury, start a new proceeding. It's not going to happen. There's two charges left, and I'm telling you what we're going to see in the next day or next week. And that's going to be, I suspect, the Supreme Court's going to take our argument that there was limited presidential immunity for official acts and send the case back down to the trial court judge to determine if the scope of what the president was doing on election integrity was deemed to be an official act within the parameters of what a president does. And I think the answer to that is yes. So this is a huge win for the president, a huge defeat for Jack Smith. Again, this is the overcharge guy. Remember, we worked on the McDonald case, Governor McDonald's, same thing there, these ridiculous interpretations of the statutes. And it comes back to haunt him every time. He can't get it right. That's why he lost his case against John Edwards. That's why he lost the first trial that he did against Senator Menendez. He's an equal party offender. He comes up with these crazy theories, and the courts never allow them.
I think, Dad, again, it almost got ahead of Jack Smith because it wasn't the court rebuking him, but now it's a pre-rebuke. They did hold it until after the debate. I mean, when you look at the other charges, too, in this case that would survive this, that weren't related to this, they were conspiracy to defraud the U.S., conspiracy against rights. Those both look like also two charges that if they ultimately got to the Supreme Court would say, that's you're looking at it too broadly.
Yeah, I think I think those two charges are in jeopardy because of the direct challenge that the president made in the brief we filed, arguing limited presidential immunity for official acts. I think Jordan, I think the entire proceeding against the president as it relates to the January 6th stuff received today a fatal blow. It's done.
So if that
receives any recovery.
So if that receives a fatal blow, and the classified documents case certainly appears like it's going that way. I mean, it's going nowhere fast, and now with the FBI having to admit they've lost some of the documents, misplaced them, they're out of order, they're not on the glossary. I mean, you really go and you look to the remaining really state charges, and the ones out of New York, as really what's left against Donald Trump and what they might try to do. There's not going to be a lot except for that sentencing date. I think that's the key thing. Democrats and the left are hoping will somehow bail out Joe Biden's performance here, is that when Donald Trump is sentenced before the next debate, obviously that happens in July, and before the Republican convention, that will somehow overtake Joe Biden's performance. But again, as you just heard my dad say, a fatal blow to Jack Smith's case out of Washington, D.C. And Dad, we did file in this case the ACLJ because of exactly they said. I mean, basically a peaceful protester. Or someone again but that's outside the Capitol, or one of our staff talking to a legislative staff saying this is how we think you should interpret this, or make sure this provision is included in a law on life, that somehow that could be again obstructing an official proceeding of Congress, and that is unconstitutional, and the court agreed, both conservatives and liberals and a liberal on the court.
Yeah, and I think, by the way, the fact that Justice Brown joined the Chief Justice's opinion is going to speak volumes, Jordan, and here's why. They're not going to be able to argue this is the six conservative Supreme Court justices that Trump appointed, and they just did their duty. In fact, to the contrary, Amy Coney Barrett sided with the liberals. Justice Ketanji Jackson Brown went with Justice Jackson went with the conservatives. So there you have it. When you have Justice Jackson going with the conservatives and Barrett going with liberals, they're not going to be arguing this political split. The law was applied. The law was applied in a bizarre way, and the Supreme Court said, we're not allowing it, period. You cannot criminalize free speech. Again, as they acknowledged, First Amendment activities, peaceful protesters could conceivably be charged with 1512C2. We're not going to allow it. That means that charge falls against President Trump. And it'll be very interesting to see how the Biden administration spins it. And they got enough problems after the debate last night. But I'll tell you, this was quite a win for the president and a huge defeat, a strategic failure on behalf of Jack Smith. Fatal is my view.
That also a major case that, again, the media has a little tougher time explaining because it's not as clear, but legally maybe the biggest case out of the Supreme Court in this entire term is the Chevron doctrine is overturned. And this idea that you go to the administration for gray areas and let them and these agencies interpret laws passed by Congress where there's gray areas and the court is not going to usually step in, has now reversed that opinion and said, no, if it's a gray area, the court is stepping in.
This is a huge thing because what was allowing was unelected bureaucrats to actually make law. And that's what I wrote a book called Undemocratic, and that's what it was about. And the Chevron doctrine being put to rest is like the Lemon Test and the Establishment Clause put to rest. Finally, we're going to have it done right. It's a very good day at the Supreme Court, no doubt about it. Thank
you, Dan, for joining us. This again, folks, I mean, when you're talking about the deep state and the bureaucratic state, the administrative state, the unelected bureaucrats, this now allows challenges to those their interpretations, and they don't go in with the idea that usually we're just going to side with their interpretation because Congress left it gray. That's no longer the position of the U.S. Supreme Court, which takes away the power of the administrative